I'd like to welcome you to this press con for CJH07312015. We thank you for your patience, and as I mentioned a while ago, the eagle has landed. Anyway, I'd like to make a few introductions. Probably don't need any introductions, but to my right is Attorney Bo Mandapat. To my left is Chairman Robert John Sobrepena, and to his left is Attorney Justin Mendoza of the Poblador Bautista Law Office. So, good afternoon, and so we'd like to begin now. Thank you.
Good afternoon. First of all, sorry for running a bit late with traffic on Cannon Road. Anyway, we're very pleased, very happy to announce the decision that was just handed to us yesterday by the Court of Appeals, Division 5, headed by Justice Tiham, where they basically, granted the petition in the case filed by not only Camp John Hay Devco, but a lot of the homeowners, residents, investors, locators, and institutions that have been with us in Camp John Hay all along. As you know, this is a case where DCDA filed for a writ of execution that basically asked CJ Devco to vacate and asked all the locators to be evicted. And of course, without due process, especially in the case of our locators. And with this, we went up to the Court of Appeals to basically ask the Court of Appeals to make a ruling on this writ of execution. And yesterday, we got this ruling, and as I said earlier, we're happy that the Court of Appeals saw it our way and granted the petition that CJ Devco had asked for. No? Our lawyer, Justin, will basically give you the details of this decision shortly, but again, we're extremely happy that the Court of Appeals has rendered this decision and hopefully has put this matter to rest. Justin?
Good afternoon. Okay, so the Court of Appeals basically summarized all of the issues that the parties raised. Because as mentioned earlier, it wasn't just CJH Development Corporation which filed the case before the Court of Appeals. There were around 50 intervenors, homeowners, owners of improvements within the camp, who also sought to intervene within the case. Camp John Hay Golf Club Inc. also filed an intervention. And likewise, Cap Trade. The issues before the Court of Appeals were essentially 5. First, there was a jurisdictional issue. The BCDA claimed that the Court of Appeals had no jurisdiction to enjoin the implementation of the writ of execution because it violated certain laws. On that matter, the Court of Appeals simply held that those prohibitions do not apply because the injunctive relief sought in this case is for permanent injunction and it no longer involves the temporary or preliminary injunctions that we sought in the beginning. Second, they questioned our standing. On that issue, the Court of Appeals held that Camp John Hay Devco as the party to the arbitration, and likewise the party ordered to vacate the leased premises and who stood to lose the leased property without payment, was certainly the aggrieved party withstanding to question whatever acts the regional trial court had carried out. The third issue was whether we had resorted to the proper remedy. The Court of Appeals simply said that we had no other remedy than to resort to a petition before the Court of Appeals. Because at the time, the writ of execution would have been enforced within a week's time. So we had no plain, speedy, and adequate remedy. Now to the merits of the case. Essentially, the issue was whether we had the duty to turn over all improvements to the BCDA without the third parties. Or to put it another way, whether the writ of execution or the final award is something that could be enforced against the third parties. Now, the Court of Appeals relied on very fundamental and basic legal principles that I'm sure we're all familiar with. The first is that in arbitration award, even when confirmed, is really something that is binding only as between the parties to the arbitration. And in this case, the only parties to the arbitration were BCDA and DevCo. The third parties, all 1,600 of them, are strangers. The second fundamental principle is that a stranger to an action can never be bound thereby. So all of the parties in this case were essentially strangers, they were never heard. And therefore any decision, whether it's by an arbitration or by a court, can never be binding on them. And the third principle is that a possessor in good faith who pays for his or her properties in good faith and for value cannot be deprived of possession without due process of law. So these were the core principles that the decision revolved around. And if we apply all of these basic principles, you cannot arrive at any other conclusion than you have to exclude the third parties from the implementation of the writ of execution, which sought to implement the final award. On the matter of payment, the Court of Appeals went back to the foundation of the final award, which is the rescission of the lease agreement. The Court of Appeals recognized that with the rescission of the lease agreement, there were several legal consequences that automatically came into play. Number one is that the obligation of Kamjan Hidevco to vacate the leased property and the obligation of the BCDA to return 1.42 billion are reciprocal obligations, meaning that they have to be simultaneously performed, and the performance of one is conditioned on the other. So in the vernacular, kaliwaan. So that was upheld by the Court of Appeals. The other consequence, which I mentioned earlier actually, is that when you talk about the rescission, it can never involve parties who acquire their properties for value and in good faith. That is a specific provision in the law. And lastly, the legal consequence of rescission is that it can only be carried out as far as practicable. The Court of Appeals held that you cannot turn back the hands of time and ignore the fact that there are people actually occupying the improvements in the camp. It is not practicable to expect CJH DevCo to deliver a property empty or free of all of these third parties. So in that sense, the Court of Appeals really went back to the foundation of the final award and gave life to it, instead of ignoring that fundamental legal principle. So the Supreme Court held that, the Court of Appeals rather, held that we cannot be expected to vacate the leased property until we are paid in full of the 1.42 billion, in line with the reciprocal nature of the obligation. The Court of Appeals noted that there is a commission on audit requirement set forth in the law, which applies to public funds and the release thereof. But the Court of Appeals recognized that that has to be secured with the assistance of the Basis Conversion and Development Authority. Now as I mentioned earlier, there were interveners, and the Court of Appeals took the occasion to characterize their rights, at least preliminarily. The Court of Appeals held that their contracts actually partook of the nature of sales. Therefore, they were buyers of improvements subject to a resolutory term which would end in 2046. So they are individuals with just title to the improvements that they have. And if anyone wants to dispossess them, a separate action would have to be filed. The mechanism indicated in the award is that it would be through, rather in the decision of the Court of Appeals, is that it would be through compulsory arbitration or if refused through the regular courts. But the idea is the same. Let us have their rights determined in a separate action. But in the meantime, there is a finding that they are buyers in good faith of the improvements that they hold. As to Cap Trade and Kamjangi Golf Club, the Court of Appeals was clear that the agreements that they had with CJH DevCo were with the awareness of the BCDA. In fact, the golf cluster, the golf club, and all of the facilities there, including the convention center, were mandated by the BCDA. So these improvements were required to be included in the master development plan. And the contracts that affected their development were with the awareness of the BCDA. So the Court of Appeals basically held that these entities were possessors in good faith and also covered by the principle that if you acquire your property in good faith, you cannot be covered by a decision of rescission. In the dispositive portion of the award, the Court of Appeals summarized basically the results of all of these discussions. So, first, it's that it directed the public respondents, in this case it's the acting presiding judge of the Regional Trial Court of Baguio City, Branch 6, and the ex-officio sheriff, and the branch sheriff of Branch 6, and all other persons acting under her. They were all prevented from requiring these CJH DevCo to vacate the leased property until it is fully paid for 1.42 billion, which is what we were saying all along. It is just a consequence of the reciprocal nature of the obligation in the final award. Now, the second portion is that in the meantime, the final award cannot be enforced against the third parties pending the determination of their rights, either by compulsory arbitration or in a separate case. So again, the Court of Appeals recognized that their rights have to be decided in a separate proceeding. And it recognized that in the meantime, they are presumptively owners with just title to their properties. Now, with specific reference to CJH Development Corporation, its obligations are basically to vacate and to cease operations, turnover management, make an inventory of the properties, etc., upon payment of 1.42 billion. With respect to the BCDA, there was a categorical statement by the court that the BCDA should respect and not disturb the rights of the third parties under their contracts. And likewise, it should assist the developer, CJH DevCo, in securing the needed TOA approval. There is also a portion in the award or the decision where the Court of Appeals said that the audit of the inventory that will be submitted by CJH DevCo should be done jointly. So that's more of a mechanical aspect of the award. So essentially, these are the elements of the award and the decision, and they are more or less in line with what we asked for in the first place. That 1.42 billion we deemed a reciprocal obligation, binding on us only upon readiness of the, or rather our duty to vacate would only arise upon the readiness of the BCDA to pay us, and that the third parties, having acted in good faith, should not be covered by the final award, the writ of execution, or notice to vacate. Thank you.
Sir, we have also, sir, are we ready for question and answer? All right, question and answer. Sir, may we have the media first, and then we'll get you. Prima Gatep of DZRH and Agents AFP. Prima?
So what's the impact of the decision of SCA as far as to the investors now? How are they receiving? I believe you've been talking to them. Maybe can you share to us about those investors or homeowners, if you could? about the impact of the significance of this order from the
Yes.
appellate court, sir?
Yes, I'd like to take that question. The impact is quite clear. First of all, the homeowners, investors, and locators, their rights are basically secure with this decision of the CA. And so the notice of eviction that was posted in their doors a few months ago have now, the CA has now ordered a cease and desist to the local branch of the RTC from implementing that. And so they're all basically secure in their homes and their investments here in Camp John Hay. And as far as their rights are concerned, I think the most material thing in what Attorney Justin just mentioned is that the CA made the ruling that they are buyers in good faith. So buyers in good faith basically means that their investments are secure and that the court recognizes those investments.
Thank you, sir. Primo?
Sir, will you, as far as that, said the attorney Mendoza said that their cases will be a separate, I will be clarified.
Yes, sir.
How so?
Okay.
Is the developer Camden Native continues or to sustain supporting them legally on a one-on-one or as it is
Okay, I'll address
without prejudice to the other councils?
What the decision actually did was to make a finding on the rights of first homeowners and then secondly on the rights of two entities who had sui generis or special rights, because you have Camp John Hay Golf Club Inc. and Cap Trade. So these are entities who have different contracts. But with respect to the more or less 50 homeowners who intervened, they all share what essentially are deeds of absolute sale, making them buyers in good faith of the properties that they bought until 2046. That is declared in the decision. If anyone wants to question that or dispute that, presumably it would be the BCDA. Then they would have to pursue that in another case. But as it stands, they are presumed to have just title. And therefore the principle, I'm sure we all know this, that a possessor in good faith shall be respected in possession until a court otherwise declares, will apply here. So that's the effect of the decision. Although there is another, it did say that it can be through compulsory arbitration or maybe through the regular courts. If, that's only if a case is pursued. But as it stands now, with respect to homeowners who have these deeds of absolute sale, and the terms are basically all the same. The court said these are buyers in good faith of the improvements up to 2046.
Thank you, Primo. May we acknowledge Dexter C. and the gentleman over there with my glasses. Dexter of Herald Express, Marine Standard today.
Must first turn over the property to the court and lay claim on the deposited amount before the court. May we know your view about this?
Yes, sir. Actually, that was the position taken by the BCDA before the trial court and again before the Court of Appeals. But as I mentioned earlier, that was not upheld by the Court of Appeals. The Court of Appeals, in no uncertain terms, said that it is upon payment in full that we should be required to vacate. And if I may quote, I think you all have it in your kits, but I'll quote it anyway. Public respondents are ordered to cease and desist from enforcing the writ of execution and notice to vacate against CJH Development Corporation until it is fully paid of the amount of 1.42 billion as indicated in the arbitral award. So, as it stands today, with the issuance of the decision, that argument can no longer hold water. In fact, if I may go to the merits of the argument itself, I think they were harping on a two-word phrase, intern, somewhere in the body of the decision, which came after the statement that we should vacate. That word intern does not appear in the dispositive portion and completely ignores, again, what I mentioned earlier, is the foundation of the final award, rescission. Rescission means mutual restitution. Mutual restitution means reciprocal obligations. Reciprocal obligations means that you cannot ask one to perform until the other is ready. It's simultaneous. Again, that is in the award itself.
Now, who will initiate? We have this decision. I think I just received a statement from BCDA that they will respect the decision. Now, who will initiate the performance of the arbitral award? Is it DEVCO or BCDA, or we need a third party to do so?
Dexter, first of all, I'm glad this is clarified. If ever BCDA will come out with more interpretations and opinions, that's all it is. Because now there's a final ruling. No? And it's very simple. They pay us the 1.42 billion along with a COA decision. By the way, that's also mentioned in the decision that there is a COA decision. And then we vacate. And so obviously the initiative comes from BCDA because they have to pay us. And once they're ready to pay us, then we are ready to vacate and turn over the camp to them. Along with, of course, the COA decision.
And along with the required inventory of properties. Thank you.
Yes, yes, we're ready with that. We're ready with any accounting and any inventory requirements that they need.
Thank you very much, sir, for the
Thank you, Dexter.
and congratulations.
Thank you.
May we acknowledge the gentleman over there, sir, please? And then we'll have the media again.
Good afternoon. I'm Rafael Evangelista, for those who don't know me.
Yes, sir.
I am here as a homeowner, and first of all, I would like to congratulate DEVCO for paragraphs number 1 and 2 of the dispositive portion. I promised Boyce Attorney Neves that I would not raise the concerns I have about this positive portion number 3, paragraph number 3. In lieu of that, I would like to ask Attorney Mendoza, how does he interpret paragraph number 3, which reads, and I quote, petitioners, interveners, and petitioner Cap John Hay Trade and Cultural Center are hereby ordered to submit themselves to arbitration, or if they refuse to submit themselves to arbitration, they should immediately litigate. I would like to know how you interpret this. On whom is the onus being placed by the Court of Appeals to arbitrate and or to litigate?
Okay. I think we're talking about the third paragraph with respect to the interveners. The decision of the Court of Appeals, the Court of Appeals in making this ruling actually was trying to find a way to have all disputes in Camp John Hay resolved already. Because one of the frustrations that was repeatedly expressed during the hearings before the Court of Appeals was that although the arbitration was intended to settle once and for all the dispute between the parties, meaning BCDA and DEVCO, what happened was we had several hundred unresolved disputes, effectively. So the Court of Appeals, in its analysis, determined that there is really nothing preventing them from ordering arbitration. Because according to the Court of Appeals, the arbitration clause in the lease agreement is also applicable to the third parties who incorporated that arbitration clause in their own agreements. So they actually have the option of suing for arbitration.
When you say they, who is they? BCDA.
The third parties have contracts with DEVCO, sir. So in those contracts, they actually incorporated by reference the lease agreement between BCDA and DEVCO. This is the Court of Appeals speaking, sir. So the Court of Appeals said, because there is an incorporation by reference, the arbitration clause can now be invoked to direct the third parties to submit to compulsory arbitration.
But
But
that
then-
would take the initiative of BCDA to do that. They would have to invoke the arbitration clause before.
That's correct, sir.
But that's not the way I read this.
Which
This
portion?
positive portion mandates the third
Yes.
parties to submit themselves to arbitration.
Actually, sir, if we read that in conjunction with the next paragraph, it's really more of an option because you can always refuse. If you refuse, you go to the regular courts. Okay, now I'd like to clarify again that I'm not speaking for the third parties. I'm speaking on behalf of DevCo. So the way that they will interpret this and pursue this will really be up to them ultimately. But that's how I read it. It's a directive to you to submit to arbitration. But if you refuse, then you have to pursue your claims before the
Then we
regular
must
courts.
indicate. In other words, the onus, the obligation of clearing the air for third parties, unfortunately, is being thrust back at us. We must take the initiative to clear the air out. Is unfortunately one way of reading paragraph number 3.
That is one way of reading it, sir. But if you read the body of the decision, what it's really saying is, thresh out your differences. As you said earlier, as if you're both parties to the arbitration clause, then you should both be able to invoke it. And one can sue the other based on the arbitration clause, which is precisely what happened between BCDA and DevCo. But by putting in that added collateral, where you can actually refuse, it actually takes away the initial directive to you. That's my reading of it. Because you can refuse anyway. So by forcing you to submit, but then giving you the option to refuse, it's not really a directive in the common sense of the word. So,
Can I suggest that when we entered into contracts with DevCo, that we had the implicit assurance that we would have peaceful possession and uninterrupted possession? By forcing us now, and I'm not saying this is DevCo, this is the Court of Appeals that I am taking issue with, by forcing us now to go to arbitration and or litigate, that interrupts our peaceful possession. Despite the fact that paragraphs number 1 and number 2 basically annul the order to the vacate and the writ of execution. Now we have to go back to BCDA to arbitrate.
Yeah, Rafi, I met with the lawyers below, and their interpretation here is that it's quite clear that the CA has made a ruling on buyers in good faith. As a matter of fact, it says all the way to 2046. Now, as far as the homeowners are concerned, no. So, and here there is an alternative, which is to refuse. So, what happens if we do nothing? Then nothing really happens, right? Because there are other provisions here that basically recognize it. Now, of course, it's a legal point that can be probably endlessly discussed among lawyers, but right now, I think at this point, we're cognizant of this, but at the same time, there is the alternative of refusal. No? In the event parties don't agree to arbitrate.
Can the homeowners request for an official legal position?
Sure, we'll have a legal opinion on the matter. Thank you.
Thank you, sir. Vincent? Balu Gib? All right. Miss Balu Pascual? Any question? No? All right. Sir, may we request also, Sir Boise, you have anything to add?
Before that, I just want to say something. Before going into the details, and what CJ Demco, the homeowners, this was not just about collecting money from DCDA. It's not just about turning over the tap, creating inventories. This was really about fighting for the rights of the homeowners, the third parties, who all invested in good faith. This is about protecting a system, not just for us, but moving forward between government and private sector and the public. Can you imagine if this went the way that BCDA wanted it to go? Who would ever buy anything again from a PPP between government and private sector? it would essentially kill that entire PPP program. Who would ever buy anything in Clark, in Subic, in John Hay, in Poro Point, even in Fort Bonifacio, when it comes to a PPP program between government and private sector? This would effectively, if it had gone the other way and people were evicted from their homes, investments taken away with due process, this would effectively have killed the credibility of any PPP program between government and private sector. So there's a much, much bigger scale to this. No? One is on the scale of the homeowners, their investments, they're in good faith. A lot of people came in here to retire and spend the rest of their lives in peace, and then the last thing they need is a legal battle, which is why DevCo has taken up the cudgels for all our homeowners and investors. But what we're really happy here is that finally justice has prevailed, and that the rule of law is finally restored back here in Camp John Hay. It was chaotic, there were interpretations, too much interpretations. One party saying it was black, the other party saying it was white. And in the middle, you had the homeowners and investors confused. Not to mention the city of Baguio. All the innocent bystanders. And we're really happy that the rule of law is restored. There is a final decision on the merits of this case. Most important is that the legal and constitutional rights of our investors, of our homeowners, of all third-party locators in this camp has been recognized. Okay? The constitutional rights and legal rights have been recognized. And finally, just to add to it, it shows something to the business sector, at the world at large even, that in the Philippines, the check and balance between government on one hand and the judiciary or the justice system on the other hand works. Especially in this case where an abusive government official has taken it upon himself to wreak havoc on private citizens and private contracts, and a PPP contract at that. And it shows that even against government, business can protect itself, okay, by way of this contract. That the contract and the rights in this contract, the obligations in this contract can in fact protect business and homeowners against government when it goes wrong. So I think that's the other element here, that there is a way for private sector to protect itself, and that the check and balance works. So this is so much larger than what we probably think. And of course, I would like to just finally say that we would like to move forward from this. We would like, we hope that BCDA stops and just complies with the court and the agreements and the rulings. Pay the 1.42 billion, get their COA approval. Let's get the project moving again. Let's get the revenues flowing back in, jobs created, and of course, giving Baguio its due course. Now, I understand that's a bit complicated now because Baguio is also claiming other things under the conditionalities. No? So, but whatever it is, it's time to move forward. Thank you.
Thank you, sir. Primo and then Ms. Malu Pascual.
Sir, Sir John, let me clarify ko lang, parang I'm not satisfied with that answer, the second one. I just reviewed your press conference several months ago. Specifically, you said the John Hay DevCo will extend legal assistance to the good faith buyers, homeowners. My question is that the same song that you're singing today?
We will sing it all the way to the Supreme Court.
Thank you.
Ms. Malu Pascual, publisher of my mic to the
Thank you. Now, what we're talking about today at the moment is the issue between BCDA and the third party, or the buyers in good faith. Now, of course, we would expect more or other action coming from the other party, because there's still one recourse left for them, or I don't know how many recourses they're still up to. Now, what I am now concerned about is the matter or the issue between Camp John Hay DevCo and BCDA. I think this is something still to do with 1.42 billion pesos. Now, will this mean to say that mag-aantayan po kayo na kung sino unang kikilos?
We are ready. We are ready to move. We're ready to vacate. We're ready to make an accounting and turn over the camp so we can move forward. The question is, are they ready to pay? And if they tell us they're ready to pay, anytime, any place, we're going to meet with them and get this done and move forward. So I think at this point, it's quite clear the initiative has to come from them. We will comply, as we have always complied, with the decision of the Court of Appeals, which basically now means that we will go to the COA. The next move for us is to go to the Commission on Audit and get approval of the disbursement of the 1.4 billion. And it's clearly stated in the decision that the BCDA must assist us in getting this approval. And that once we have the approval of the COA, then they pay us and then we vacate.
Okay.
I think this is now the process. So to answer this question, with Camp John Hay DevCo will initiate the whole process by seeking approval from the COA immediately.
Okay. What happened now to the during our last conference? I remember you showed us a document purportedly pertaining to an escrow account with DBP. Parang doon sila nagbayad or nag-deposit. Ano na po nangyari doon?
Well, first of all, we didn't show you that. They probably did. Okay. But first of all, that so-called escrow account is not really an escrow account. It's just a special account of BCDA. They own that account. And it requires their approval to disburse from that account. That account is still there, the money is still there. The Baguio RTC, more specifically the sheriff, the ex-official sheriff, actually wrote BCDA if they could release the money from that account to the RTC, to the Baguio RTC. That letter went out last May. I think it was around May 17, if I recall. Okay, right? Okay, and to this date, that money has not been transferred to the RTC. So if BCDA or Mr. Casanova says we have paid them, the money is there, it is meaningless, completely meaningless. Why? Because it requires his signature before it is released. A true escrow account does not need the consent of the account holder. It only needs the compliance with certain conditions. A true escrow account will have a condition. You put it with the escrow agent, once the conditions are complied with, automatically releases the money. There are no conditions in this account. Furthermore, it requires the signature of BCDA. And last, it even requires a COA approval. Okay, so in essence and in short, the money is there, but it's meaningless and cannot be used.
Okay. Thank you.
Okay, may we have Balugir? Please, Malu.
Good afternoon, sir. And sir, what about the management of the hotels? I think it says somewhere here that the operation should be turned over. Is this in reference to the actual management of the hotels?
Yes, thank you. The management of the hotels is really an agreement between a management company called Club Leisure. And by the way, the management contract is between Club Leisure and the third-party unit owners. So it's a private agreement between the owner of the condo or the unit and the management of the hotel. Okay, so it is a right of a condo unit owner or even any homeowner to get a manager to manage his home, unit, or condominium, or in this case, condotel. So if the third-party rights are respected, then therefore the agreements of this third party must also be recognized. And so the hotel management stays. So that's not the management they're talking about. The management of the golf club is the same way, in the sense that the golf club is owned by members. The members elected a board, and the board manages the golf club. So that management will not change either. Okay, the management this refers to would be the management of the camp, cleaning the roads, cutting the grass, collecting the garbage, collecting the kusa, paying for the utility bills, and security of the main gates. This is basically the management that they refer to.
Sir, is there even the smallest possibility that there's a crack in that in those words, turning over the operation to mean that the rights of the owners will only mean their possession, and that the operations may also imply, turnover operations may imply that the order can sever the contract between the owners and the management party that they have chosen?
Yes, no chance, no cracks. Why? Because the agreement between the homeowner is basically with a private company, Club Leisure. It's not with DevCo. The management of the golf club, DevCo is not managing the golf club. It's managed by a board of governors elected by its members.
Any more? So some of the media went ahead to file their story because they have a deadline. So this story will be out tonight and for the weekend papers. Any more questions? Vincent? Okay, that's it. Sir, final words from our panel. Sir Boise.
Yes, well, I don't want to repeat a lot of the things that have already been said. Mr. Secretaria had very well articulated our position. All I wanted to share is the fact that not only do we have a victory here today for our third parties, our homeowners, our residents, but this is also another vindication. A vindication of our position that we have all along been fighting for. So once again, we'd like to thank all of you in the media for your fair reporting out there, and not just looking at the other side, but also looking at our side, fair reporting, and we appreciate your support. And we will, once again, also the third parties that are here today, we thank you for coming, and we are here to continue fighting for you, and that's a promise. Thank you.
Thank you, sir. Attorney Pong, okay. Okay, that ends our press conference. Thank you. Good afternoon.